Okay, good morning, everybody. Today is Tuesday, April 1st, 2025. It is 9 a.m. and I'm going to call the Real Estate Commission meeting to order. Director Waters, may I have roll call?
Michelle Espinoza.
Here.
Erica Doyle.
Here.
Renee Lind.
Here.
Autumn Rubal.
Here.
Erica Sanders.
Here.
You have a quorum.
Wonderful. David, I'm going to give you a few minutes if you want to discuss with the public CE credits.
Thank you very much. Members of the public, I have launched a poll for anyone that is seeking continuing education credit in accordance with the Colorado rules of for the Colorado Real Estate Commission. So if you are seeking that, I will leave this poll up for a moment, or a minute or so here. Please complete that. And with that, commissioners, I'll pass it back to you and you may proceed. Thank you.
Thank you so much. Looks like we need approval of the February 4th, 2025 Real Estate Commission meeting minutes.
I move that we approve the commission meeting minutes from February 4th.
Second.
Great. Thank you. First and second. Any discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes. Is there any public presentation of issues not on today's agenda?
Members of the public, if you would like to address the commissioners, please select the raise hand icon and we can unmute you. Commissioners, seeing no hands.
Okay, great. We have this morning a hearing matter with oral arguments and deliberation. My question to the commissioners is, would you like to enter into executive session to discuss the case prior, or at least protocol? I know some of you have not been in a hearing before. Would you like to go into executive session prior to the hearing to get some legal counsel?
I would say for me, no.
Okay.
I'm good.
Okay. Autumn or Erica, would you like to do executive session at this point?
I think I'm okay for now.
Okay. All right, hearing none, we are going to, sorry, I am just looking. My papers are a bit askew this morning. I apologize. All right. We will now take up the hearing matter case RC-2023-0029. Colorado Real Estate Commission petitioner versus Mark Fetter, ER 400006577, respondent. Oral arguments are scheduled to be heard today on respondents' exceptions to the initial decision. Present to assist the commission in reaching a final agency order are Melissa Phipps, Senior Advisor, and Sue Kim, Assistant Attorney General as Conflicts Counsel. David, may we check their audio?
We've confirmed that both Ms. Kim and Ms. Phipps are able to speak at the current time. Yes.
All right, wonderful. The administrative law judge conducted a hearing on sanctions for violation of a broker laws and issued an initial decision. Exceptions to the initial decision have been filed by respondent. The commission as petitioner has filed a response. The commission has had an opportunity to review these materials. The parties have been informed that oral arguments will proceed today, beginning at 9 a.m. Mountain Time. Each party will have 10 minutes to present arguments. Then the commission will deliberate on whether to adopt, modify, or otherwise act on the initial decision and proceed to a final agency order and final discipline, if any. All right, we're going to move on to oral arguments. I will ask each party to identify themselves. Appearance for the petitioner, Colorado Real Estate Commission, please.
Irina Groni, Attorney General's Office.
Thank you. Appearance for the respondent / licensee, Fetter, please.
And David, you may have to turn on audio for Mr. Jordan May.
Mr. May and Mr. Fetter have both been allowed to unmute.
Thank you.
I'm here.
Good morning, commissioners. This is Jordan May, counsel for Mr. Fetter.
Good morning. Let's proceed with oral argument. Parties, please note that the commission members have had an opportunity to review the initial decision, exceptions, response, and the administrative record. Please recall, no new or additional evidence has been offered or considered. Each party will have 10 minutes for oral arguments. I will call the respondent first, followed by petitioner. Questioning by commission members will not count against your 10 minutes. My fellow commissioners, it is important for each of us to understand the position of each party as presented in the written exceptions and response and as presented in today's oral arguments. I will call for commissioner questions before each party rests from its argument. I will ask each commissioner to please focus your questions on what is necessary for the commission to reach a decision. David, I will ask you to serve as our timekeeper. Please signal the parties when their time has concluded. For respondent, please proceed with your argument.
Commissioners, good morning. This is Jordan May. Technologically here, I don't have an option to turn on my camera. It's not on my screen. I'm happy to proceed audio only. It might be nice if you can see me, but that's not presently an option I have on Zoom for some reason.
David, is that something we can allow for him?
Mr. May, I've promoted you to a panelist, and so you should have access to activate your video at this time.
Yes, thank you. Here I am. Good morning, commissioners.
Good morning.
Thank you, David. Commissioners, I will be brief here. I know we have a meeting agenda to get through. First of all, I want to thank you all for your consideration of Mr. Fetter's case here at the exceptions oral argument phase. Very briefly, I want to provide a factual background here. I assume, commissioners, you've all read both the initial decision, our exceptions pleading, as well as the commission's exceptions pleading. And I'm not going to sugarcoat any of this. This involves first a stipulation for diversion dated July 22nd, 2021, in which Mr. Fetter agreed that he had not completed required CEs. We've referred to that as the 2021 stipulation. And these facts are undisputed. Mr. Fetter did not timely comply with the terms of that stipulation. Ultimately, he did complete the coursework under that stipulation, but it was late. It was in July of 2022, after the deadline. He had also not paid the fine then. For that reason, the commission and its counsel pursued a notice of charges in September of 2022, resulting in a final agency order of January 11th, 2023, and Mr. Fetter did not participate in that proceeding. Here we are with the present case. This was filed, a notice of charges filed on July 24th of 2023. Mr. Fetter did participate in that proceeding, and we have seen Mr. Fetter pay down the fines after the filing of that notice of charges. We are here today to address the initial decision issued by ALJ Light following the hearing that occurred in July of 2024 regarding Mr. Fetter's previous noncompliance. And to be clear, Mr. Fetter accepted all of the facts regarding his noncompliance with the 2021 stipulation, the 2023 FAO, and testified to his life circumstances. And that's an important factor here that we're asking you to consider. His life circumstances included his sustained sobriety. An important feature of the case that we're here today to address is that it's not driven by complaints. We have no evidence of a harmed consumer. Instead, we have a concluded statutory violation related to CE compliance that Mr. Fetter did not contest. Judge Light issued her initial decision dated October 4th, 2024, and she set out in her initial decision a set of factual findings and legal conclusions, specifically a violation of Colorado Revised Statutes 1210, 217, 1M, and no other license law violation. And she also recommended discipline. I just want to be clear, what are we here for? What am I talking about here today? We are not here to dispute the factual findings, and we are not here to dispute the legal conclusions. And let me speak plainly, commissioners, what we are here for is to ask for leniency. We're here to ask for leniency in terms of the discipline only. And permit me to explain why. First of all, there has been a suggestion by the commission's counsel that perhaps the commission should not or somehow does not have authority to decide a different disciplinary outcome than what is recommended by ALJ Light. And I just want to be clear that the law sets out very clear guidelines for the commission to substitute its own decision, its own judgment for ALJ Light's decision. And the authority for that, I think, is pretty plain. It's Colorado Revised Statutes 24-4105, parenthesis 14A, and that is confirmed in Colorado State Board of Medical Examiners versus Ogden, 56 Pacific 3rd, 1233. The PIN citation is 1237. Here, commissioners, what we're asking for is for the commissioners to fully consider the mitigating factors. And specifically, those factors are alcoholism and sobriety. Mr. Fetter testified very clearly that during the COVID-19 pandemic and after that pandemic unfolded, he experienced significant repercussions and an exacerbation of problems with drinking. That caused a serious impact to his practice, to his business, including a loss in his financial income. Mr. Fetter also testified at the hearing that as of the date of the hearing, which occurred in July of 2024, he had been sober for 643 days. And that number is contained in ALJ Light's initial decision. Sobriety, commissioners, as evidenced by Mr. Fetter's testimony, is a life change. And as we've seen, as Mr. Fetter's testimony bears out, it requires a sustained effort and even dedication. Changing one's course of their life takes investment, dedication, and time. We've seen that Mr. Fetter, after he became sober, participated in these proceedings. He hired me. I'm here today speaking on his behalf. He's been paying down fines. He took responsibility and he repeatedly apologized for his prior misconduct. He did not make excuses. He owned it. Mr. Fetter, as he testified, is now the primary sober caregiver for 2 teenage daughters. Commissioners, I'm a student of agency discipline. I think a lot about how state agencies impose discipline on licensed professionals. There is not a robust body of law that addresses this. Instead, we're left with bits and pieces from the courts that tell us what the parameters are for deciding what discipline is appropriate. And we have a case, Colorado Real Estate Commission versus Hannigan, that sets out that the penalty is not supposed to be manifestly excessive in relation to the misconduct and the public need. And so we use this effectively a comparison between the misconduct, and there is clear misconduct here, and the needs of the public. In other words, we evaluate the public impact and we use those factors to decide if the discipline is manifestly excessive. The same idea has been reiterated by the Court of Appeals, including the unpublished decision that we cited in our exceptions pleading. And we use that same framework to decide here what's appropriate, what's fair, what should be done to Mr. Fetter and his real estate license. And when we look at the public impact in this case, what we see is that it's minimal to none. It's really theoretical, right? The fact that a licensee does not complete their CE compliance, that's a significant license law violation, but it has no direct impact on a consumer, right? It's very important. It's very important that we all maintain license law compliance. But part of the framework that the Court of Appeals is telling us very clearly that we should evaluate is the impact on the public. And here it's theoretical. We have no evidence of a direct public impact. We have no evidence of a harmed consumer. Certainly this case is very different than the cases the commissioner considers where there's deception or conversion of funds or stealing or even a monetary loss because of negligence. We have none of those features here. We have none of those features here. If we accept this as true, then revocation does appear to be manifestly excessive when we take the needs of the public into account. Now, I want to be clear here. There is no dispute that Mr. Fetter's license should be disciplined. We are not here to say that he should not undergo discipline. He should, and he accepts that. The concept that we're proposing is that the discipline be one of the commission's authorized disciplinary measures under CRS 1210-217(1), including the possibility of something less than revocation, something that has not been tried previously. So for example, commissioners, probation, especially a probationary term where a violation of a probation for any reason would result in his revocation. And so commissioners, we are asking for leniency for those reasons. We are asking that you give Mr. Fetter a chance, place him on a very strict probationary term, for example, and permit him to continue to practice under the careful, watchful eye of the Division of Real Estate. Commissioners, if I may, I'd like to reserve the balance of my time, if I have any, and address any questions the commissioners have.
Thank you very much, Jordan. I did have a question.
Please.
Have the fines been paid in full from that July 2023?
That is an excellent question. So I want to be clear about one point here. One, we are very strictly prohibited from entering into this argument new facts that the ALJ did not find. However, she did find that Mr. Fetter had paid the $862.50 from the original 2021 stipulation. As well, her initial decision recognized that Mr. Fetter had been up through the date of hearing, continually paying down his fines in increments. And beyond that, Commissioner, I need to respect the bounds under which this hearing is occurring, including the prohibition against new evidence. I can tell you part of her initial decision is a recognition that he has continually paid down his fines.
Thank you so much.
Jordan, has he continued to practice real estate?
Commissioner, my understanding is yes, there has not been a prohibition against him continuing to practice. You all have the authority to issue, as I understand the law, you all have an authority to issue a final agency order which will directly impact his license. There's nothing impeding his practice in the record as of this moment. So there's no prohibition against his continued practice as a licensed real estate broker as of this moment.
Sorry, I guess I should unmute. I apologize. Renee, did that answer your question for you?
Sort of. So he's still continued. Is that his main source of income? Does he have another source of income? Has he been doing things in sales?
Commissioner, the initial decision found specifically that Mr. Fetter does rely on his license for income, including supporting his family, his 2 teenage daughters, and that Mr. Fetter's own testimony is recited in the initial decision is that loss of his license through revocation would have a very severe impact on his finances.
Okay, so we
I
don't
believe the
really
answer is yes. The answer is yes.
But we don't really have information to support or dispute that, correct?
That is true. But the initial decision does not set forth any notion that he doesn't rely on his license. He does. To me, that much is clear from the decision.
Renee, I think what Mr. May had in the back end said is he can't enter in any new evidence, like we're supposed to go off of what was in these in the documents we received. So I think
So we don't have an answer, but that's how
yeah.
it is. Okay.
I think we can only go on what we have from the ALJ and their petitioner, the information we have. We can't enter in any new information, but we didn't impose anything on his license before, so he still can work. He still can do transactions because nothing has been signed or so that is my understanding. Does anybody else have any questions? All right, hearing none. Mr. May, thank you so much.
Thank you, commissioners.
For the petitioner, please proceed with your argument.
Good morning, Madam Commissioners. Just a brief reminder that in this portion of this public meeting, I'm appearing not as your general counsel, but as the prosecutor of this matter. So as you know, if you will have any legal questions, you should address them with your conflicts counsel. With that, let's focus on Mr. May's argument. The story told by him is undoubtedly sympathetic, but is a drastic departure from the story told by Mr. Fetter himself by his actions during the past 4 years. I agree that revoking someone's license is a severe outcome, but in this case, as the judge found, and as I will explain, revocation is the only appropriate remedy. Mr. May's argument today have not done anything to move the needle. Let's focus on the facts of the case as they appear in the record. The facts are that Mr. Fetter's license has been suspended or inactivated 6 times in the past 7 years. In 2021, he failed to comply with his continuing education. He also failed to respond to the division's investigation. He admitted to both violations and agreed to a stipulation for diversion. In the stipulation, he agreed to pay a modest fine of $862 and to complete 24 hours of continuing education within 30 days. He asked for several extensions to comply with the stipulations. The commission granted all of his requests. Despite this, Mr. Fetter did not timely complete his continuing education. He also didn't pay the fine. The commission again gave Mr. Fetter additional time to come to compliance. He didn't do so. If he would have complied with the stipulation, his discipline would not even be visible to the public. So only in July of 2022, he finally completed his continuing education. He completed it only because he was unable to renew his license without it. In September of 2022, due to his continuous failure to pay, the Commission filed a notice of charges to enforce the stipulation. He did not respond to the notice of charges. So while Mr. Feder continued his pattern of non-compliance, the court issued a default. After that, the division again worked with him for several months and provided him with many opportunities to comply, including offering a payment plan. He failed to comply. So in July of 2023, the Commission filed for these current proceedings. The division spent an unprecedented number of resources attempting to bring Mr. Feder to compliance, but to no avail. So to recap, the original non-compliance took place in 2021. Today, in April of 2025, we're still dealing with Mr. Feder, trying to bring him into compliance, and he is non-compliant. So let's shift our attention from the facts to the legal argument. We are here today because Mr. Feder has demonstrated that he cannot be regulated. His history of continuing non-compliance left the judge no choice but to revoke his license. In his pleading, Mr. Feder didn't challenge any of the evidence, nor the fact that he violated the law. He even admits that discipline is warranted, but objects to the revocation. However, he lacks legal justification for a more lenient sanction. At best, his pleadings put forth two unsupported claims. Number one, that the judge did not address harm to the public. And number two, that he is a recovered alcoholic. Mr. Feder relies on you being sympathetic and wants, based on that alone, for you to substitute your judgment for that of the judge. But the Commission cannot do that because the Commission must follow the law. So let's talk about the law. To succeed on exceptions, Mr. Feder must demonstrate that he asking for relief that has reasonable basis in the law and is supported by substantial evidence in the record. His pleadings do neither. He didn't cite any legal authorities supporting a lesser sanction, and he failed to identify any evidence, let alone substantial evidence, that supports a deviation from the judge's decision. The judge has heard all the witnesses and considered all the evidence before issuing her ruling. The ruling is appropriate and should stand. So this brings us to a conclusion. Revocation is appropriate here. While not unsympathetic to Mr. Feder's current situation, this is a situation that he have easily been avoided had he paid a nominal fine and completed his coursework. The Commission and the Division did everything they could to work with Mr. Feder to avoid serious consequences. He simply refused to comply. He ignored prior proceedings and didn't take matters seriously until his license was at risk. He alone is responsible for the present circumstances. His continued non-compliance must have consequences. So given the totality of the circumstances, revocation is the only appropriate sanction. It is also important to note that after a year since the revocation, Mr. Feder can reapply for his real estate license. There, he will have a chance to prove to the Commission that he is worthy of a license. But until then, the revocation must stand. Therefore, petitioner is asking the Commission to accept the initial decision as issued, including all the recommended sanctions. Thank you. Do you have any questions for me?
Thank you. I do not have any questions. Do any of the other commissioners have questions?
I don't have any further questions, no.
Nope.
All right. Thank you, parties in council. This concludes oral arguments. David, if you wouldn't mind cutting the audio and visual for parties in council. All right, so I will give the option for executive session at this time if we feel like we need to speak to conflicts counsel before we go into open session deliberation. Does anybody need executive session?
Would be in favor of it for a few minutes if possible.
Second.
All right. All right. We have a motion and a second.
Just to clarify, Madam Chair, if I may,
Mm-hmm.
that the executive session is being requested to convene under section 24-6-402 sub 3 sub A sub 2 of the Colorado Revised Statutes for the purpose of conferring with the Judicatory Council and receiving advice on specific legal questions and issues related to the case under consideration, number RC 2023-0029, Colorado Real Estate Commission versus Better.
I believe we had a motion. Who was that motion, please? It was Autumn. Thank you. And our second was
Erica.
Erica. Great, thank you.
We should probably clarify which Erica.
Erica Doyle.
Erica Doyle. All right, perfect. All right. This is Michelle Espinoza. The time is now 9:32 a.m. on April 1st, 2025. And we are going to, actually, I'm sorry, I don't think I asked for a vote. All in favor of executive session?
Aye.
Hi.
Aye. Any opposed? Okay, motion passes. Now, it is 9:33 on April 21st. I don't know what my problem is today, everybody. I'm so sorry. April 1st, 2025. And we are now going into executive session. So please mute and cut your video for this one and go over to the link for executive session. I believe we're just waiting for Commissioner Sanders. We just don't have her on video.
I'm here. Not sure why the video is not on. Hang on for just a second. I think it has something to do with the camera within executive session. So hang on 1 second. Okay.
You are.
We're back.
Okay, great. We are now going to do our open meeting discussion. So the commission will now deliberate. I invite commission members' discussion of this matter. Would any commissioner like to open the discussion?
I don't mind opening because I took extensive notes and and will ask for forgiveness as I go through all of this real quick, but I do think it's important. So after reviewing all the materials, first off, I think it's great that he's on the sobriety path. It's a big deal. But I have 4 takeaways in the case. Number 1, the respondent doesn't dispute any of the factual findings in the ALJ's decision. Secondly, the respondent admits to all the initial noncompliance in 2021, which was related to the CE, and he admits to not complying with the terms of the stipulations, not meeting the deadlines regarding the coursework, not paying the fines timely. He also admitted to not participating in the 2023 proceedings that led to the final agency order, as well as not complying to the terms of that 2023 final agency order. I noted that the respondent wants the commission to consider his sobriety along with the lack of harm to the public as we make our decision. And then I noted that the respondent states that he can, in fact, be regulated as a licensee. And I think it's regrettable, for one, that all of this spiraled just from the lack of response and lack of compliance, or I should say lack of compliance regarding the CE credits, because that was kind of minimal discipline. And I do sympathize with his personal afflictions that, kind of got him here. But I think that we all recognize and appreciate, his efforts. However, our responsibility, as I see it, isn't to analyze his rehabilitation or his sobriety. Rather, we're charged with upholding the rules and standards of the public. And, I think that we have an obligation to comply with professional standards across the board. And even if no direct harm to the public occurred in this case, the repeated non-compliance still matters, in my opinion. And these things are in place to prevent public harm before it happens. And most importantly, we as a commission board have to maintain trust in the public in the system, right? And so I think it's a detriment to the system if we allow further leniency, because it does set a standard that that's okay. So overall, I agree with the ALJ in that there is a huge amount of uncertainty with regard to the respondent's ability to be regulated. We can only make decisions based on what we've seen. And unfortunately, what we've seen is more consistency with the non-compliance than the compliance. So for those reasons, in my opinion, the respondent's arguments do not provide significant findings to reverse the ALJ's decision. And I think the ruling is appropriate and sufficient given the circumstances. Of course, I'll hear the opinions of, the other commissioners, and we can go from there. But, and I even want to kind of echo what we know is that there is a path to licensure after revocation. So I think maybe that needs to happen, and he can kind of have a fresh start.
Okay. Erica, that was well said. I appreciate that. I agree with you 100%. I also would like to add the argument that not doing CE is it harmful to the public? I would like to counter that it could be very harmful to the public. If you are not taking your CE, the reason it's there is to keep everyone up on any changes, what's happening, etc. It is education, and the public can definitely be harmed if someone is not doing their required CE and keeping up on things. So I think that is extremely important.
I will just go ahead and echo again what Erica and Renee have said. I agree with them wholeheartedly in this situation. I am sympathetic to the situation, and then I'm pleased that Mr. Fetter is moving forward on a good path. That being said, I think that the education is key in our industry, absolutely key in our industry, and that non-compliance and non-responsiveness in this would have been easy to do. So I think I would go ahead and agree to what was recommended by the ALJ, and don't believe that any changes were necessary on that.
Lastly, I'll echo all the comments from my fellow commissioners, wishing Mr. Fetter the best as his path towards recovery. And in a year, hopefully he can apply for licensure.
All right. Thank you all very, very much. So at this point, I think there seems to be a unanimous decision. You know, I'm a big proponent of education. For me, it's, you know, I was wavering a little bit because it's unfortunate that one pandemic wasn't easy for anybody, you know, and I think that really made some people's lives just even more difficult, and why there is sympathy. Yes, that was, you know, unfortunate that life took a turn. You know, I hate to see that something as easy as, you know, Commissioner Sanders said, as education, right? Such a minimal in the length of things that you could do to on license law to hurt your license, that this is causing revocation. But I do think that the five of us are on the same page. It's unfortunate that it has come to this. However, you know, there is, as it's been said before, a path to come back. So with that, would any commissioner like to make a motion on what the sanctions are going to be, whether that's holding up the ALJ's decision? We will need a motion.
I would make a motion that what was stated by the ALJ is approved. Do you want us to reiterate that, or?
I think we may need to. Do you want me to? I have it in front of me. Do you want me to read it and then you can just?
Sure, that's fine.
Okay. I move to adopt the initial decision in its entirety, including the findings of fact, conclusion of law, and to order discipline as recommended. Compliance with the remaining terms of the 2021 stipulation, if any. Compliance with the remaining terms of the 2023 final agency order, if any. Public censure. $2,500 administrative fine plus mandatory surcharge under section 24-1052 CRS for a total of $2,875 and a revocation of respondent's license. So that motion, as read by me, was done by Renee. Do we have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes. A final order reflecting the commission's decision will issue in due course. A copy will be mailed to the parties by commission staff. Thank you, everybody, for participating in that hearing. We are going to move on to today's order of business. So we have policy matters with Director Waters.
So, excuse me,
Oh.
Before you move on and before I excuse myself, if I could just clarify whether the commission will like to see the final written order or delegate authority to either staff, the chair, or a single commissioner.
I'm fine with delegating authority to senior advisor.
Yes.
Deb.
Yes.
Me as well.
So Renee, is that okay if you make that
Yep.
motion? Okay.
Motion to delegate authority. We don't need to say it again, but delegate authority to write that up and get that.
Okay, and who was our second?
Second.
Okay, Commissioner Doyle, thank you. Great. All right, thank you so much. Was that all you needed from us, Sue?
Yes, if I could just confirm whether there was a vote. I think I might have missed that part.
I told y'all I'm on the struggle bus today. I really do not know. I apologize. All those in favor?
Aye.
Aye. Any opposed? Motion passes. All right.
Thank you so
Now
much,
we have our
Madam Chair
conclusion.
and Commissioners. I will excuse myself at this time. Thank you.
Thank you.
Thank you.
So
All right.
commissioners, before I launch into the legislative update, I wanted to give you an introduction of the new deputy director for the division. His name is Garrett Lyle. And Garrett actually worked for us previously, took a 5-year hiatus from us to go to a different state agency. He was previously an investigative team lead with us, and he is now the deputy director. So you will see him throughout your meetings, but I wanted to at least give you a formal introduction to him.
Welcome back.
Commissioners. It's good to be back. I look forward to working with you in the future.
Awesome. Welcome.
So on to the legislative update. The division is tracking about 34 bills, but there's a couple that specifically kind of impact you. There's House Bill 25-1202. This is the Mold Awareness and Registration Act. It's going to result, if it passes, is going to result in us having to modify so far the seller's property disclosure about mold disclosure issues. It's kind of like the radon disclosure bill from a couple years ago, but it's a little less complex. And then as of yesterday, there was a bill introduced. It was Senate Bill 25-264, which has to do with transferring certain cash funds to the general fund. This is going to impact the division because they are looking at transferring $200,000 from our fund over to the general fund. It was just introduced yesterday, and there hasn't been any communication from the department about it yet, but it has a financial impact on us. Of the other 32 bills that we are tracking, a lot of those have to do with landlord-tenant issues. They don't impact the commission itself or our forums, but we're tracking those specifically to then, once they pass, or if they pass, those will be included in your annual commission update course, just for education for the licensees. We also have the HOA sunset review that is moving through that doesn't affect the commission, but affects the division. So that's just kind of what we have going on. I think there's a couple bills that potentially may impact the forms, although they don't specifically call out changes to the real estate commission forms. So if you would like to see kind of a bill report, I can send you one of those as far as what we're tracking. But it's just a reminder, the department works with the governor's office on bill positions. So the real estate commission can't take a position independent of the department on any specific bills. And I'm just flagging these bills for you to let you know that we are tracking them. And when appropriate, like with the mold awareness bill, we did provide comments to the bill sponsors. We were allowed to take a position of amending that. So we are tracking those bills for you. Any questions? Okay, well, I will turn the next portion over to David, and that is the 2025 Education Task Force.
Thank you for your time this morning, commissioners. I'll be brief. As the Education, Communications, and Policy Program Manager here at the division, I'm joining you today to present you with the 2025 Colorado Real Estate Commission Education Task Force members. as you may know, historically, the Education Task Force is a group of educators, instructors, associate brokers, employing brokers, property managers, attorneys, as well as division investigators. These professionals assist the division with general guidance, educational approvals, qualifying education outline reviews, and most importantly, the development of the annual commission update course each year. Simply put, the goal of this task force is to improve the education experience for brokers across the state of Colorado. So this year, I am presenting you with an excellent group of individuals again, and therefore, without further ado, I'd like to identify those individuals by name and what they do, and then from there. So first, Patrick Armbrust from Armbrust Real Estate School, Heather Bustos, an employing broker at Compass Real Estate, Damian Cox, an attorney as well as an educator for Cox Education, Jesse Farnloff with the Colorado Real Estate School, Todd Franklin, an employing level broker with Coldwell Banker, Dana Garrett, an employing level broker, a real estate agent and an instructor with the Colorado Real Estate School. John Gillum is an employing level broker. Holly Krell with the Colorado Association of Realtors. Rob Lind, a managing broker with Milestone Real Estate Services and Property Management. He's also a broker. Beth Ann Mott is an employing level broker with Berkshire Hathaway Home Services, Colorado Real Estate, as well as an education provider and trainer. And Eric Romero, the Director of Broker Management at Your Castle Real Estate. In addition to these very, very qualified individuals, we also have 3 dedicated staff members this year. That is Patricia Hardy, an investigator with the Division of Real Estate, AJ Jackson, an education specialist with the division, and then myself. So with that, I am very happy to answer any questions that you may have if you deem that appropriate. And then I respectfully request that you approve the Colorado Real Estate Commission Education Task Force members for 2025 by a motion, second, and a vote. Thank you.
Thank you, David. Sounds like a good group of people. I don't have any questions.
I motion to approve the 2025 Education Task Force.
Second.
Thank you. First and a second. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes for the 2025 Education Task Force.
Thank you, Commissioners.
So Commissioners, the next item on your agenda is we're following up on the supervision and Commission Rule 6.3. To give you a little background, in February of 2024, we had presented some revised rules to you. One of them was 6.3G. And based on comments that you received at that rulemaking hearing back in February, you actually decided to repeal Part G. And you tasked the division with gathering some information, which we have done. We sent out a survey to all of the employing brokers that are licensed with us. I've given you those survey results. It's kind of a mixed bag as far as whether broker associates are sharing confidential information with their employing brokers or not. One of the issues that we'd identified kind of leading up to the rulemaking a little over a year ago was we'd had a few complaint cases where the employing broker was privy to confidential information about the client that the broker associate was representing, and then the employing broker was involved on the transaction on the other side and used some of that confidential information to the detriment of the represented consumer that was on the opposite side of the transaction because both sides occurred in-house. And I also reached out to some of the defense counsel to get some of their comments, which they weren't due to get back to me until this Friday, but a lot of them responded in advance. So I just provided you with those comments. Really, the division just wants to see what you want to do at this point, if anything, so that if you would like to see some changes made, we can go ahead and start that process. Otherwise, you can definitely leave it as it is with Section G repealed. And the AG's office is also here to provide you with legal counsel if that would be helpful to you.
So Marsh, I had a question on the red line that you sent out on the 6.3. There's something added in there about the dual. Was that the whole section was taken out, so that part wasn't approved because the whole thing was removed. So we could just leave section 6.3 in there, take out the piece about the dual and just leave it how it had been, correct?
You could look at bringing back the old language of G. I think your attorneys may have something to tell you about that. The concern is that you've got a couple statutes that are on the books that you need to make sure that your regulations are consistent with. Brokerage relationships, while there's confidential information that goes between the designated agent and the client that they're representing, the statute says that that information does not flow up to the employing broker. Although you've got a listing contract that basically straight out of the gate waives that for the consumer without them really being able to contemplate whether they want to waive it or not. And then you've got the other statute that really isn't something that you enforce. That's if there's a litigation, that's a civil remedy that's available that they can go after, the harmed consumer can go after the employing broker because there's been a breach of a fiduciary duty, which would be sharing confidential information without the consumer's consent. So I think whatever you decide to do, we just have to make sure that it is consistent with the statutes. You don't get to ignore state law or do something contrary to it.
Well, the 6.3G that we had been in place for years and years, and it hadn't been an issue till just recently. And I was very confused about some of the answers on that survey. I don't understand how some of the brokers were saying they couldn't keep confidential information confidential. And I don't understand that. So there, in my opinion, if you can't keep that confidential and still handle a transaction, there's a problem and maybe you shouldn't be in that position. I don't understand what the problem is. You shouldn't have to reveal any of that information. If you are overseeing something, you don't need to reveal it to anyone else. So I'm very perplexed about a lot of those answers we received. Anyone, you know.
And I came in really, kind of blind to all of it. Of course, I had to understand what the issue was since I wasn't part of the commission when this all came about. But from the employing broker standpoint, there's always going to be confidential information potentially that you're going to have. Confidential information is very broad. It includes, person's name and address, right? Which is all in that transaction file. So a broker is gonna have access to confidential information. To me, I think what was important, and also let me just say that as an employing broker, you are responsible for supervision. And part of that supervision is making sure that you can comprehensively counsel your associates. To me, I think the biggest issue is like honing in on what the real confidentiality issue is. And I would say that would be like motivating factors are probably the biggest confidentiality issue, right? And really how to navigate and protect that. Although there are instances where, as an employing broker, your associate may have to disclose elements that would be considered motivating factors. So I do understand the concern, especially when a brokerage is representing both sides. And I thought there were some decent suggestions in there. course, not being an attorney, I don't know which way to go with it, but you know, number one, looking at the survey, there was a small percentage of brokerages that really ran into issues. And I think that there was a recommendation where we created a rule, or, you know, about how the info can be safeguarded by the employing broker. I was kind of more leaning towards that making a lot of sense. Someone else suggested that, sorry, I'm looking at my notes here. Someone else suggested maybe a form when that kind of conflict arises, but reality is managing broker is gonna potentially get confidential information, and it's really important that they are able to counsel their associates. So I don't know. I know I said a lot and nothing at the same time, but hopefully we can dig into something from that.
Erica, I thought your comments were very good. Also yours, Renee. I have my notes here as well. And I came in after that meeting in February also, so I had to really dive into this. As a managing broker, you are given confidential information, and I think that the vast majority, I would hope, certainly understand their position that they need to safeguard that confidential information, but their primary goal in that role is to help those brokers through that transaction, help those clients, and they need to be able to do that. So when they come to them, I think if more brokers consistently sought guidance and assistance from their supervising brokers in those critical moments, we'd see less of these issues in front of us. And so we certainly need to have the opportunity for that guidance. And I feel like consumers have the expectation of that there is a supervising broker, an employing broker that is watching that. So I think it's important we have that in our contracts, and I think it's important that we have a rule that is in place. And so I was kind of surprised that that had moved out of our manual. I'm going back to my notes on this. My apologies. And I'm not sure how one gains competency as they go through all of these without some of those nuances, if we were too limited in any way, as far as what they're able to tell that supervisor, because sometimes the key as to motivation is critical in the guidance that they would be given. You know, particularly when we have licensees that are brand new right out of the gate. I mean, they don't know what they don't know until they get into that. And so they really do need a lot of hand-holding in that. Let's see. When we went into the survey, I know that it was kind of all over the place on there, but it seemed to me that the problems were somewhat limited on that. There weren't a lot of major issues that came up on that survey. So I think that overall, the systems that we've had in place and that were kind of in the notes that we were given as well have worked well throughout the years. So I think that the problems are probably that maybe we can handle that again with legislation, and we have some suggestions here to maybe add that into the rule that comes back in. So we're addressing that in maybe a rule that we could put back in place. Is that something that everybody else saw as well, where we could kind of put back in something similar to what we had, but address those sections specifically so that we have clarification? And that's maybe a direction that I would like to go, but have additional commentary from the commissioners.
I think that's
Totally.
good.
I was gonna say, I agree with
Yeah.
that for sure.
And I'm trying to remember back to when this discussion happened, and I think part of it was there was not enough clarification, or it was not felt by the members that there was not enough clarification of the rule of So I think that's why it ended up being just repealed. And given the opportunity to rework it, right? And that's why I think Director Waters has made this effort to get input from, interested parties, and so that it does come back in front of us. So I think at this point, I don't know, Marcia, at this point, is it getting staff together to recreate the rule under incorporating those new legislative issues, or what does that look like?
So we're more than happy to draft for you guys to consider. We just need guidance on what, like, do you want to resurrect the old point or section G? Do you want to put some guardrails in there about how the employing broker is supposed to manage that confidential information, including possible delegations of authority? Because you have to consider not all brokerages have 200 plus brokers where it's easy to do a delegation. You're dealing with also very small brokerages, and how do they manage confidential information when they are representing both sides of the transaction? And you could have two newbies on both sides that require a high level of supervision. How do you protect that confidential information?
And I think that was our sticking point last time, right? Was when you have parties, you're representing both parties and they both need that direction. Where that, I think it was felt that that rule as it sat did not address that completely. So I think that's where we're stuck. And
Well, we had legal advice from our attorneys on what to do, and I would like to kind of go with what they had recommended, and I would recommend then we put the rule back in as it stood and leave it alone. I believe that was their recommendation. And
Members, Madam Chair, this is Gina Simonson, your counsel on this issue, and I'd like to interject here because I'm recommending that if you do have legal questions about the advice that was related to you from the division, that we go into an executive session. I'm listening to the commissioners talk about a lot of different concepts and reference confidential information and the various statutes that might address confidential information, and I think it would be helpful to have some legal advice, what's actually out there now in the licensing law, what's out there in your rules and your position statements, and perhaps give you some options, some legal options to consider for moving forward. And I hate to belabor this meeting because it's been long and we would be needing to go into a separate executive session, but I would recommend it at this juncture. I would like the opportunity, Commissioner Lind, if you had been looking at that advice, to kind of clarify it for the rest of the commission.
okay.
Yep, great segue. I was actually going to ask if they wanted to go into executive session, so perfect. So do we have a motion to go into executive session to confer with legal counsel and receive advice regarding policy matters C, division follow-up on broker supervision and commission rule 6.3?
Yes, I make that motion.
All right, do we have a second?
Second.
Great, thank you. First and a second. All those in favor?
Aye.
Aye.
Any opposed? All right, 5 votes in favor of executive session. We will now enter into executive session. Please make sure you mute your audio and All right, it looks like we have everybody back. For record keeping purposes, we did go into executive session at 10:18 a.m. I apologize, I did not announce that before we went in. I believe, in this matter, with policy matter division follow-up on broker supervision and commission rule C3, I believe Commissioner Doyle has a motion.
Okay, I motion that the division implement a rulemaking proceeding in compliance with the guidance we received in executive session for the administration rulemaking process to proceed.
You have a second?
Second.
Thank you. A first and a second. All those in favor?
Aye.
Aye. Any opposed? Motion passes. I think we'll do agenda items, and then if everybody's okay, we'll take a 10-minute break, if that's okay. So
Anything
go ahead,
you'd like
Marcia.
on your June agenda, commissioners?
I don't have anything.
You may not be here for the June meeting.
I know, that's why I have nothing.
The conclusion of Michelle's 2 terms on the commission.
Yes, today. All right, if we have no recommendations for the agenda items for next meeting, let's take a 10-minute break and be back at 11:02. And we'll start up with complaint investigations and audits.
Okay, good morning. Investigative matter A is complaint number 2024-1556. On June 24th, 2024, the respondent pled guilty to misdemeanor assault in Denver City and County Court. The guilty plea was part of a deferred judgment and sentence in which the respondent received a 12-month probation sentence. The respondent is serving his probation out of state in Florida and has inactivated his Colorado real estate license. Possible violations are 1210-217-1M, 1210-217-1N, 1210-217-1P, and Rule 6.23. Disciplinary recommendation is diversion, a fine of $500, and probation that is concurrent with the criminal probation. Investigator Coates is here to answer any questions you may have.
Thank you. Any questions?
I move to accept staff recommendation.
Thank you, Renee. Maybe a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
All right, investigative matter.
On this item, next item B, I will be recusing myself due to possible actual or perceived conflict.
Great. All right, go ahead, Sarah.
Okay. Thank you. Get back to the chat. Okay, investigative matter B is complaint number 2024-1842. The complainant began working with respondent to find and buy an investment property. Complainant cannot read or write in English, but he can speak and understand some English. Instead of helping him buy a property, respondent persuaded him to lend for $300,000 that would be secured with her solely owned property. Respondent told him she would pay off the loan within a 6-month period. Despite respondent's representations, both verbally and through recorded documentation, that she was the sole owner of the property, respondent's ex-husband held an 18% interest in the property. Complainant alleged that respondent recorded documentation indicating that the ex's interest in the property was terminated and given to the respondent via a quitclaim deed and a tenancy in common termination. Because of respondents' misrepresentations related to ownership of the property, the ex-husband sued complainant and respondent. Complainant had to hire an attorney to settle with the ex-husband and engage in a lengthy civil suit against respondent for repayment of his loan. Complainant obtained a default judgment against respondent. However, respondent has never paid him back, and he is still awaiting a share of sale of the property. Other noted potential violations include creating, providing, and recording false documentation, dishonest dealing, and failure to maintain real estate documents for a period of 4 years. Possible violations are 1210-217-1K, 1210-217-1V, 1210-217-1W, 1210-217-1M, 1210-217-1Q, and Rule 6.20. Disciplinary recommendation is a final agency order, public censure, revocation, and a fine of $12,500. And investigator Danny's Wright is here to answer any questions you know.
Thank you. Any discussion, questions on this case?
I move to accept staff recommendation.
Do we have a second?
Second.
Irina, did you have a question?
Yes, commissioners, if I may, in this case, since we have a lot going on, would you mind amending the staff recommendation to the fine of $12,500 or max fines?
Nope, we can put that in motion to accept staff recommendation with the addition of fine of 12,500 or max fines.
Thank you.
Second.
Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes. Right, if we want to just give it a second so that Commissioner Doyle can rejoin.
Should we do all the ones where she's exempted together so we don't have to go back and forth? She's got 3.
I just texted her, so she should
Oh,
be coming back.
Okay.
Okay.
All right, ready for matter C.
All right, matter C is complaint number 2025-246. On February 10th, 2025, the respondent self-reported discipline against her Arizona real estate license and her company's license. The consent order and accompanying investigative report illustrate errors in the respondent's property management agreement. The respondent was ordered to pay fines, take continuing education, have all contracts reviewed by an attorney, and submit monthly transaction logs to the Arizona Department of Real Estate for a period of 1 year. Possible violations are 1210-217-1X, license discipline in another jurisdiction. The disciplinary recommendation is diversion and a fine of $500. And investigator is here to answer any questions you may have.
Discussion or a motion?
I move to accept staff recommendation.
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Matter D. Sorry, which ones are is she recusing on? I'm sorry, Erica.
E and L, I believe.
Okay, just wanted to make sure I wasn't
Thank you.
proceeding. Okay, so matter D is complaint number 2024-1371. The complainant filed a complaint against his listing broker. The complainant alleged the respondent was negligent in listing his Colorado Springs. The complainant and his wife had an existing assumable VA loan on their residence. The complainant stated their loan was assumable, however, they needed to retain their VA eligibility for a new purchase in California. The complainants further stated that the respondent was aware of the requirement. Through the course of the complaint, it was discovered that nothing was put in writing by the respondent to protect the seller's VA eligibility. Possible violations are 1210-217-1Q, 1210-217-1M, 1210-404-1B, Rule 6.2. And the disciplinary recommendation is a final agency order, a fine of $5,000, and coursework in contracts. Investigator Levy is here to answer any questions.
Questions or discussion?
I thought we should add coursework in assumable loans. Not sure what there is on that, but I thought we should do something that goes over that because this is an issue and there's a lot of this going on. So I would move to accept staff recommendation with adding the addition of coursework and assumable loans.
My only concern would be that such a one-off. I would ask division staff if they can't find a class like that, if we're imposing that as discipline, what the alternative is.
Yeah, this one was very interesting because, I mean, although there's nothing in writing that was specifically to retain those benefits, when we're going into assumptions, and we are seeing a lot of this now, we're going to see a lot more. I think this could be a problem. I listened to the interviews on this. And I think what was really important, that the seller, obviously he stated he's not transferring his eligibility, but we don't have anything in our contracts at all where you can, when you're talking about assumption, that you can state anything about what you might be retaining in your lending. And we regularly will say, hey, if you're talking about anything to do with a loan, you need to talk to a loan licensee. You need to talk to a mortgage provider. And this particular licensee tried to bring in an assumption specialist to handle that and kind of fill that gap in that area. So it was very interesting listening to kind of how this progressed. And the respondent states all the way through, they were overall very happy with this particular licensee, except for this particular portion, which was massive, but they want this to happen so that it doesn't happen to other agents. So or other sellers. And so I really wanted us to focus on that a little bit, because I think we have a problem that we should look at in the future too. How would somebody know on that particular one when we have no way of retaining somebody's eligibility? If you didn't know specifically to write in a paragraph stating, yes, you can assume my loan, but we're going to retain eligibility on this. That is something that is key and only came in out of the interviews on that one. So, sorry, I have some more notes on here. Let's see. And it seems like the person that was originally, or the company that was originally brought in to handle that VA assumption was, I'm not exactly sure how they moved out of that. And then it was moved over to the buyer's lender. So I do feel like the respondent was trying to bring in somebody to handle that aspect of it.
So my take on it is I agree with some of that. I do think in the beginning of the process, there was an attempt to try to kind of bridge that. I'm going to call it a competency thing. One thing that should have been a red flag from the very, very beginning of this is that the potential, or the buyer, not a potential, the buyer did not qualify for a VA loan. And that should have set off the red flags right there. So to me, that was definitely a competency thing where, if that particular licensee, if that individual was not aware of that, that's problematic, because that's kind of like the very first thing. It was very clear that the seller they communicated that they wanted to retain that. And so to me, from the very beginning, the fact that there was not enough due diligence to even determine if the buyer was getting a VA loan. I mean, that's the number one part of that process. So I do agree that if there's a option for coursework, that would be warranted in this situation, just because, to your point, Commissioner Doyle, I mean, I think we'll see a lot of these types of cases, and I think education is going to be really important. But again, as a practicing licensee, I know that the very first thing that should have created that red flag was the fact that the buyer didn't have or wasn't eligible for a VA loan. And that should have been determined before they even went under contract.
So if it helps the commissioners, I did just look up what classes we at least are aware of currently that are on this subject matter, and there are several about assuming loans, assumable mortgages. There is one specific on VA loans.
Great.
So the assumable ones tend to be about 2 hours. The one specifically on VA is 1 hour. So if you did want to add that coursework, those courses are available.
Okay, so I'll amend that we motion to accept staff recommendation with coursework. Should we be specific? The coursework in VA assumable as well as assumable loans. I think we should do both. That would be 3 hours. You said it was 2 and a 1. So it'd be 3 hours, assumable loans. 1 is for VA and 2 is for just assumable.
I'm going to comment that, or question maybe, the assumable loan, do we know if that covers all loan types? Because I think that would be appropriate and fine if VA is included in that coursework.
Can't tell by just the listing that I'm looking at right now. There are several course providers that are offering that. And so I'm sorry that I don't have that information. I don't have the actual syllabus in front of me.
Maybe just 3 hours of assumable loans, something of that nature, or a certain amount of hours.
But we wanted to include the VA though, because right now there's a lot of FHA as well. So we want to make sure it's including the VA because of the eligibility. So as coursework and assumable loans to include VA loans.
Yeah.
Okay.
David, thank you. You've had your hand up. Would you like to give some introspect here?
Yeah, I just wanted to clarify a couple of things. Number one, the buyers did qualify for the VA loan, but there's a huge difference between qualifying for it and having that VA eligibility. It seems like that got lost in there a little bit. Number two, I would caution you on anybody providing that course. These folks did take a course offered by the company that's not licensed. So whoever they take a course through, I'm sure Penny makes sure that they are licensed and approved by the Division of Real Estate.
And thank you for providing that clarification, because my interpretation was that they didn't qualify for the VA loan, but you're saying that they qualify for the VA loan, but they just were not eligible.
Because they were not veterans or active military, they had no VA eligibility. You can still qualify for the loan, which is
See, and I see that differently, because if you never served, you can't qualify for a VA loan. And maybe it's just terminology that we're using.
You can assume one without
you can
having
assume one, but you can't qualify. So I guess the point that I was making in the beginning is that if they did not have a pre-approval letter that stated they are pre-approved for a VA loan, for example, that should have been red flag that this whole transaction probably wasn't going to work. And there should have been further investigation once that was noted. So if they were not prior military, they would not have ever been given a pre-approval for a VA loan. So that's kind of what I mean. And that should have been, and because the seller was very adamant that they wanted to keep that benefit, in my perspective, I think especially someone that had been educated even a little bit on the assumption process should have the understanding that in order to transfer that benefit, you need to be eligible for the VA product, which they were not from the beginning.
Thank you.
Well, and that was kind of my, hold up on some of this. And I agree there needs to be, we need to have, education and fines on this for sure. But she did check with the lenders on here, and there was I think it came down to a miscommunication on the term eligibility, because they were transferring the eligibility for them to move forward and buy, the sellers be able to buy another home moving forward. And so that was the crux of the miscommunication, is they were going to lose their eligibility to use a VA on the following end. So they qualified the entire time. The buyers had qualified the entire time for it.
Right, but because the seller stated to the agent in the beginning that and I believe, I have to look back on my notes, but I believe that the agent acknowledged that they stated in the beginning that they wanted to retain that benefit. Like I said, that should have created a red flag, and it should have, at least, if nothing else, created a little bit more due diligence.
Agreed.
And that's really my issue with it, is just, okay, well, once you realize from the beginning that this person, I don't know we didn't get information as to what type of loan they had, but let's say, for instance, it was an FHA loan or a conventional loan. Once that came through, it should have been a little bit of a red flag. But I do understand there seems to be miscommunication between the seller and their agent as well. So,
Okay, so we do have a motion that was made by Renee. Do we have a second on that motion?
I second, and that was with the coursework, is that correct?
Yes, the additional coursework on assumable loans that included VA. So we have a first and a second. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes. Erica, if it's okay with you, Renee had a great idea. So maybe we do E and L together. That way you only have to recuse for one little more time period. If that's okay with staff, we'll do E and then L.
That sounds good. And then I'll just go ahead and say I will be recusing myself from E and L due to possible actual or perceived conflict.
Okay, thank you. Okay, we are ready for matter E.
All right, complaint matter E is number 2024-1845. The complainant is an appraiser who alleged the respondent attempted to influence the selection of an appraiser by making a false claim of conflict of interest to the appraisal management company. The investigation did not identify supporting evidence for the reported conflict of interest, but the respondent denied the allegation of the complaint and provided additional reasons for canceling the appraisal appointment. The first being that her client needed to reschedule due to personal issues. Secondly, the respondent referenced a previous transaction in which the complainant had valued the property $40,000 below the contract price and then became unresponsive, causing unnecessary delays in the closing of the transaction. The respondent also indicated that her client in the same previous transaction had expressed concerns that the complainant's abrupt behavior and conduct during the appraisal inspection might have been in part due to racism. Lastly, a broker in the respondent's office claimed the complainant was very inconsiderate toward a homeowner during an appraisal inspection for a transaction in which the property was valued 20% below the contract price. Possible violations include 1210-217-1Q, and disciplinary recommendations include diversion, a fine in the amount of $1,000, and coursework in ethics. And Investigator Walker is here to answer your questions.
I actually have a comment on this one. I kind of struggled with this a little bit. So first, I see a conflict of interest personally. We have an appraiser who she has had interactions with prior. So personal that there had been an exchange of some sort. And so to me, when it says there was no conflict, I would expect that in a scenario where there had not ever been any interaction. So I felt like she was being honest about the conflict of interest. And I can see where that would be a conflict of interest, because she did have personal experiences with him that were perceived negative, from her standpoint, whether that's true or not. And I don't see it being wrong for her to bring that up to, to request maybe a new appraiser, because the reality is, had that individual that she's had a negative interaction with, had they, let's say for an example, appraised the property low legitimately, that would never have been accepted because of her past experiences with this individual. So I think personally, she did the right thing by saying, hey, I have a conflict. Let's get another unbiased appraiser on this file, because we've had a negative interaction in the past. Personally, I think that she did the right thing. So I don't really believe a violation occurred.
Anyone else? Oh, go ahead.
So I was just going to say that I think that is certainly relevant to the conversation, and that is one of the key points that you need to determine. In evaluating the facts of the case, I think when we looked at a potential conflict of interest, we're looking at circumstances or relationships that would cause competing motivations on the side of the appraiser, that could affect their neutrality or their objectivity. And you can make the argument that the previous interaction and the personality conflict or the concerns from those previous transactions fall into that category, but we were looking for something that more specifically would inhibit the appraiser's ability to do an appraisal with that neutrality and with that objectivity.
And yeah, I still kind of hold firm that how do we know that that was possible when they have had a negative interaction? I mean, in the response, they noted that in the respondent's response, it was noted that there was a property that was appraised low. It went into a tidewater, which basically means they're challenging the value. There was a correction on the value. So, and then additionally, there were claims, which we don't know if they're false or what, or accurate or what, but there were negative claims about the experiences that the clientele had with this individual. So I guess my concern about this being a violation would be, I feel like it would restrict others that may have had these kind of types of experiences and not allow, I mean, I guess let me just back up and say, I don't really understand the issue with getting another appraiser involved when that's going to be still an unbiased scenario and there's no influence on price, right? So I guess, because that was one of the comments, is that this influenced, or this was an attempt to influence the value, which I don't see how that's possible, considering another licensed appraiser just coming in on the transaction because they've had the other appraiser and this individual has had a negative experience with one another, which I do feel like that could be a conflict of interest.
Okay, so I'm going to take the other side. Unfortunately, I didn't see all those things that you saw, honestly. The prior one I didn't think was that much of an issue. So I thought it was valid that they were trying to influence things. You can't just get a new appraiser because you used them before and they came in low. That's not a reason to get a new appraiser.
But that wasn't her complaint solely. It wasn't because it came in low. It was because of the interaction, how he treated the individuals in the property. There was multiple reasons for this complaint. So not just to influence value.
Right. But I thought some of the supposed interactions, etc., were not necessarily verifiable. It looked like there was a lot of hearsay in this to me. So I thought the recommendation was okay.
And then the question would be like, if it went through, how would, if for some reason, I'm just going to give it like a worst case scenario, some reason appraisal comes back low, it negatively affects the seller. Now, does the seller feel some kind of way that that agent of theirs that's representing their best interest didn't act on their belief that this would happen? So I don't know. I just don't see the violation. But I would love to hear other, other commissioners take on it too, because I just don't see it.
Okay, so how about if we split the difference? Unless someone else want to weigh in on this one?
I'm trying to remember, did they end up doing the appraisal?
No, they hired, it sounds like another appraiser came in and appraised it, which, I don't see the problem with that.
Commissioners, we also regulate appraisers, obviously under a separate board. Interfering with an appraiser and a client's relationship, though, is not appropriate, even when it's a real estate broker. And there is a federal law about appraisal independence. So that kind of falls into that. There are some significant penalties at the federal level. And there isn't a fiduciary duty to have an appraiser removed from an assignment because you're the listing agent for the seller. Conversely, if that appraiser did evaluation and it came in below the listing price, if they've done an unbiased appraisal and it's well supported, that is in favor of the buyer as well, because they shouldn't be paying more than the market value of the property.
Yeah, I agree with that part for sure.
So all in all, the discipline on this case is not very steep. Other than I was questioning the fine. One, it's not marked on my copy, but we're doing diversion and I would question the $1,000 fine. Maybe a $500 fine. But that was my thought.
I was poking back through the file. Forgive me, was there a second appraisal ordered? Because if there was, I'm not seeing it in the file.
I believe there was a second appraisal that was done by another appraiser. We did not receive a copy of that.
I was curious if there was a substantial difference between the two opinions that could warrant the support of what Erica is saying.
The first one didn't have an opinion at all because it was canceled 20 minutes after he had scheduled his appraisal inspection.
But I think maybe what Marcia's saying is that, the appraisers are regulated. And I think because I know in my history on the commission, we've seen this matter context come up a few times. And so I'm trying to recall, but I think there are procedural channels that if you have an issue with an appraiser that you can go through to get that redirected or maybe redone. I'm not sure because I don't deal with that. And those cases have been a little bit, but Marcia, I think we've seen this scenario a handful of times. And there are avenues, right, for a seller if they don't agree, or a seller's agent to go down a different path and maybe request. I don't know if that's coming across correctly, but
Appraisal is so that the lender on the buyer side can evaluate whether that is the risk that they're willing to take on lending on that property. So if the seller's unhappy with an appraisal, they can always complain to the Board of Real Estate Appraisers, but I will tell you, we don't have jurisdiction over value itself. But like I said, like if the appraiser follows their standards and has a supported appraisal that comes in lower than the listing price, it doesn't mean that there's a violation of the practice standards, and that's in the buyer's interest. Why should the buyer be stuck paying more because the appraiser didn't hit the desired value of the seller's agent? They are a neutral, unbiased party there to evaluate, help the client, which is the lender, none of the real estate brokers in this transaction, and the buyer is not even the client. The appraiser's job is to help the lender in their evaluation of whether there is sufficient collateral in that property to assume the risk of lending on it.
And I guess,
And you've seen a couple of these, and it's been a mixed bag. You have discipline on the last one that you saw, which I think was about a year ago. There was another one where with the fact pattern, I don't think you guys believed that you had enough to discipline the broker for.
I think what I'm struggling with, and I appreciate the clarity in terms of like the appraisal side of things. I guess what I'm struggling with is that maybe not understanding the appraisal side. I guess I don't understand why this agent canceling the appraiser at the beginning of the process before value was initiated is deemed as influencing value.
Because she's interfering with the relationship between the appraiser and their client. Additionally, I mean, you could go down the road of potentially that's affecting the sale because she's interfering with the buyer's loan and their ability to get a loan, if you want to kind of view it that way. So that's a different nuance to this. And we don't enforce the appraisal independence laws. Those are federal laws, but this kind of cascades down into looking at when you have a real estate broker that's interfering with that relationship and having an appraiser that is appropriately credentialed and competent to perform the appraisal removed, then you could perceive that as being unworthy and incompetent in their actions.
Okay.
if there are no more questions, may we get a motion?
Did we, I have a question. Did we settle on the fine? Because it was brought up that fine should be addressed.
Well, I was just asked, that was my question. One, it's not marked, and I think that was just a clerical error, that box was not marked, but it says a fine of 1,000. You know, so if that's somewhere where you feel like maybe that could be down, I mean, I felt 500 was appropriate. So that's up for discussion, or we can leave it at the 1,000.
Any other commentary from the commissioners on where to leave that? Leave it or to reduce it?
I would leave it where it is.
Autumn, you as well?
I mean, I'm in favor of reduction, but I guess you're a tiebreaker, Erica.
The appraiser doesn't work for the broker. The appraiser works for the lender. They shouldn't have their hands in this stuff.
Yeah, and I'm accepting that perspective, certainly. But I will go with the majority to reduce the fine and keep the diversion and the coursework.
Erica, would you be comfortable making a motion?
Yes. I motion to accept the proposed discipline with the amendment that the fine would be reduced to $500.
Okay. Do we have a second?
I'll second.
Okay. Any Any further discussion? All those in favor?
Aye.
Aye. Any opposed?
Aye.
All right, we've got 3-4. Motion passes. And then now we are on to matter L.
Good morning, Commissioners.
Good morning.
Matter L is complaint number 2024-1467. The complainant, who was the owner of 2 commercial rental properties managed by the respondent, alleged property management competency issues in record keeping, trust accounts, 3-way reconciliations, and disclosures. The investigation found possible license law violations. Possible violations include 1210-217-1Q, 1210-217-1M, Rule 6.2, Rule 6.5, Rule 5.14, Rule 6.20, and disciplinary recommendations are a final agency order, a fine of $2,500, coursework in trust accounts, coursework in property management, and a high level of supervision for 2 years, and additionally a follow-up audit within 90 days. And Investigator Geske can help answer any questions.
Thank you. Any comments or questions on this one?
None from me.
Same.
Nope. I move to accept staff recommendation.
Do we have a second?
Second.
All right, thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes. And if we can invite Commissioner Doyle back in.
He's back.
All right. We are now on to matter F.
Matter F is complaint number 2024-944. In investigating the complaint allegations, the investigation found that the respondent failed to abide by her brokerage duties and failed to exercise reasonable supervision over the activities of licensed employees. Possible violations include 1210-217-1Q, 1210-217-1R, 1210-217-1K, 1210-217-1M, Rule 6.3, Rule 6.14C, Rule 6.20, and Rule 6.26. Disciplinary recommendations are a final agency order, a fine of $4,000, coursework in brokerage relationships, coursework in brokerage administration, and a downgrade to an associate broker with a high level of supervision for 2 years. And Investigator Gabarty can help answer any questions that you may have.
I have a question regarding, this is an ER license that I believe supervises 35. So what happens in that case when you're downgraded to an FA for 2 years with high level of supervision? Does this one have a co-managing broker?
You've got to get somebody else to step in that position. And
Exactly.
yeah.
So Michelle, in those situations, we would coordinate so that we don't take down the entire lot of folks underneath it. We would give them time to get, an appropriate person in place. So it's a bit of a coordination just to implement that, but we do it.
And another question I had for the disciplinary recommendations, downgrade to FA for 2 years. And it was mentioned with a high level of supervision. So are you wanting a higher level than what, like a brand new license, or is there a specific way we need to, if that's the way we go, notate that in the discipline, in the license?
Yeah, we could add either a reasonable level of supervision or a high level of supervision.
Those were my questions. Anybody else have any questions or discussion?
None for me.
But Michelle, for clarity, even when we ask for a high level, it is just the level that a new broker has. It's not additional to what a new broker would have. So it's either as a new broker or as an experienced.
Okay.
So we don't need to add that verbiage then, Penny? We just,
If you want the high level, like a brand new one, you
Okay.
do need to add that verbiage.
Okay.
If you just want her under the supervision of an ER, but don't feel like it needs to go back to the new broker, then you don't.
Okay.
so Michelle, what were you wanting? Were you wanting the high level or just the normal?
Oh, I was just looking for clarification. I think the normal, I think is fine. You know, they've been a broker quite a bit. I mean, so
Okay, because it's written right now, just normal. So
right. And so I'm fine with that. It was just mentioned when it was being read with high level of supervision, and I guess clarification from in my mind. I just wanted to know what that downgrade looked like. So I'm fine with how it is.
Okay, well, I move to accept staff recommendation.
Second. Okay. Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes.
Matter D is complaint number 2024-2289. The Missouri Real Estate Commission conducted an investigation of the respondent's broker license and respondent's brokerage licensing, finding that the respondent had been conducting real estate services with an expired license. In both cases, respondent was fined $1,000. The fines have been paid in full. Respondent was then fined $500 by the Pennsylvania Department of State upon self-reporting the Missouri discipline when renewing his Pennsylvania real estate broker's license. This fine has also been paid in full. These matters were then disclosed to the Colorado Division of Real Estate, but not within the required 30 days. Possible violations include 1210-217-1M, 1210-217-1X, and Rule 6.23. Disciplinary recommendations are diversion and a $500 fine, and Investigator Gabarty can answer any questions.
Any discussion? May I get a motion?
Motion to accept staff recommendation.
Second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Matter H is complaint number 2024-615. 5 months after obtaining a real estate broker license, the respondent represented herself in the sale of the subject property, a fix and flip. The respondent failed to make buyers, including the complainant, aware of information related to the condition of the subject property that a reasonable person would describe as actual significance to that information, specifically the reason for demolition of a sunroom. The investigation also found that the respondent failed to draft an amendment to her exclusive right to sell listing contract, reducing the list price. Additionally, the respondent provided the complainant an addendum to the contract to buy and sell and a disclosure of personal interests that did not include the required commission language. Possible violations include 1210-217-1M, 1210-217-1K, 1210-217-1Q, 1210-217-1C, 1210-4043A, and Rule 7.1. Disciplinary recommendations are diversion, a $2,500 fine, coursework in ethics, and coursework in property condition, discovery, and disclosure compliance. And again, Investigator Gabarty can answer any questions.
I actually did have a question on this one. Did the respondent or complainant, I guess, provide any evidence of like inspection reports? I didn't see anything in the documentation that we had. I was just curious to know if the respondent in fact knew that there were issues with the roof or with the solarium. But I could.
Commissioners,
Go ahead.
no inspections were done by the respondent either during the time that she purchased the property or while she or after having purchased the property. No inspections were done.
So I guess my only concern would be buyer one, right, which I think is a complainant. The respondent may not have actually known when dealing with buyer one of the issues. Now, buyer two is in question, because if buyer one had an inspection done and that report was shared with the respondent, then at that point, the respondent knew about these and then it was undisclosed. So I guess I'm just trying to figure out if there really was deliberate and false misrepresentation as well as failure to disclose. I'm just wondering if like there was any documentation that showed that she actually in fact knew.
When the buyer was looking at the property, they were told about the damage in the sunroom. And then they were also told that the seller didn't want to do a seller's property disclosure. So the buyer was aware of the rotting wood, etc. So
right, and they made from what I recall too in my notes, they made reference to offering lower prices and trying to get concessions because they were aware of the solarium being an issue, but the roof was kind of the thing. It was unclear if there was actual knowledge of the roof, which ended up being the bigger issue. And even buyer two was aware of the solarium because they specifically noted that they offered less because of it. So, I mean, if they were asking for contingencies and a lower price based on what they physically saw, I think that they're acknowledging that they see that there's a problem. But I guess the question was really about the roof. For me, was there knowledge about that or not?
In regards of the deliberate misrepresentation of false promise or failure to disclose?
The failure to disclose, yeah.
Okay.
That was the only thing. I just, I was kind of looking through all of the evidence and different things, and I couldn't necessarily come up with that conclusion, but that doesn't mean that that isn't the conclusion. I just didn't see any documentation that specifically shows that this individual was aware. I definitely think there's violations on other for sure. I think these other violations are completely valid. That was just the one that I questioned.
Right. But buyer two, though, they did not disclose to buyer two, correct?
We don't know. That's what I'm saying. I don't know. That's what I'm asking. Because the complaint referred to, the complainant was under the impression that buyer two wasn't informed. And the reason they were under that impression is because the MLS was never updated during so buyer one canceled, but they immediately went into contract with buyer two. And then the next thing was the MLS was updated to say that the deal fell through because of finance. So buyer one is under the impression that they're not disclosing information that they knew. However, when you kind of read both sides of it, the agent didn't change the status because it was like a day different. I think it was maybe the same day or 1 day difference. And they have like 3 days to update the status in the MLS. but then the buyer 2 did fall out for a loan. And then they ended up coming back and kind of fixing everything. So that's the only reason. It was just a little cloudy for me. I just was unclear if there was sufficient evidence to say that there was no disclosure, and I just really don't know. So I was just asking if there was something solid to say that there was disclosure or non-disclosure. I'm sorry.
One of, not specific to the respondent directly, however, I have a side question is that I know, and maybe this is for staff, but this respondent only had their license for 5 months. And in the background, it says that their firm was not aware of this transaction. Being that you're a new associate broker, everything has to, I mean, unless I looked at the contracts, looks like it went through their current broker. So or the broker at that time, why was that whole transaction not looked at from their managing or employing broker? Where was the supervision for this 5-month licensee? Because a lot of these things may have been, cut off at the pass or given some direction. So my question is, where are they in this situation? And the accountability that should be on them.
So my team lead and I did discuss this with regard to supervision, and the respondent didn't make anyone aware of these transactions. The first transaction, buyer 1, ultimately ended up terminating. Nobody was aware on the brokerage side. Come buyer 2, the only reason why she was even informed that a seller's property disclosure was required is because that transaction then closed. So until the brokerage firm became aware that the transaction was going to follow through and end up closing, the brokerage firm wasn't even aware that this respondent was conducting these transactions.
I guess that's part of my question. Procedurally, I obviously am not a broker, but if you have a new licensee, isn't that part of your job and why we have that high level of supervision that what your brokers are doing? And I don't know if there's checks and balances. I don't know how that works. So that's why I'm asking procedurally, like, should this have fallen through the cracks? I mean, are there not checks and balances within a brokerage, within what their duties are to their brokers, that this should have been caught? I guess is my question.
So you're saying the brokerage firm should be investigated?
I'm saying that I think I'm questioning their due diligence. I'm questioning if they're doing what they are supposed to be doing as an employing broker. That is a big concern of mine. If you don't know what your brokers are out there doing, especially with a 5-month license, that is huge consumer harm.
Yep. Yeah, it's good that you brought that up because it is something that I thought about too when going over everything. To the investigator's point though, you don't know what you don't know, and it's hard to supervise if you don't know that there's a transaction happening. And that, where does that responsibility lie, right? And I'm sure there's office, and you would hope there's probably office policy and protocol about that. And I don't know if there was any discipline in that, from the office where this took place. But I think if the broker or brokerage firm had been aware, absolutely. But the fact that this individual didn't turn in a file, and I would imagine that, there's some sort of policy that requires that. You can provide the requirement, but we can't, people have to follow the protocols. And so maybe that is what happened here. But I think the fact that the brokerage didn't know kind of lets them off the hook a little bit. And when they did know, it sounds like this is why this all came up. So or at least the seller's property disclosure. I don't know. I still have the same question though. So do we know for certain that there was a failure to disclose material fact? Was there any documentation showing like did they present any inspection notices or reports, either of the buyers, just to show that, hey, this was sent to this agent, so this agent was well aware of these items? Do we have that at all?
So again, there were no inspections done. However, with buyer number one did bring to her attention there was a severe issue with the roof. And respondent did state that she had asked for that buyer's inspection report as well as an inspection objection, but the buyer just decided to terminate right off the bat. So buyer number two comes along, and the broker for buyer number two even stated to the respondent, look, we're coming in at such a low price because the solarium and the roof are a mess. So even they brought that to her attention. And she demoed the sunroom because her contractor told her it wasn't good.
So would it be misrepresentation if they were aware of it before they contracted?
Aware of what?
The issue, the fact, I guess that's what I'm just, I don't know.
So she demoed the solarium prior to listing the property.
Right.
She did what she could to rectify the solarium because according to her contractor, who never, according to my report, stated to her that there was anything wrong with the roof, just that the solarium wasn't good. And as stated in my report, she tried to price out windows to replace the broken windows that were filled with moisture. She did try to price out windows, but it was just too costly. So her contractor said it's no good. So she chose to demolish the whole thing. And by demolishing that and taking down the solarium, it left that gap, that opening between the roof and the solarium. It's gone, and that's just totally open now.
Right. But I guess what I'm getting to, was she aware, did she have the expertise to say that this was a problem? Like, so that's kind of what I'm getting at is, was she aware the extent of the problem? Did she, and I just don't know if there was enough documentation to support that I saw. And I'm just making sure I didn't miss anything.
When you buy a house that is way cheap, it looks too good to be true. It is. There are going to be problems with it. This property was cheap. She tried to flip it. So she bought it cheap. You know, there's lots of issues, and she tried to make a whole bunch of money on it. So no one's selling a property that's cheap unless there are problems. So
well, and again, I just want to mention that they noted that both buyers noted that they offered based on these same issues. So that's why I'm like, did she really, I mean, if they're offering low because they say, hey, this sunroom looks like it has problems, I want to address it, so I'm going to offer you, considerable amount less. So I don't know. I guess just to sum up the conversation, I just question the failure to disclose. So
and I think the fine is too low. I think that I would vote for an increased fine. This was a huge deal. There's the whole thing going on with the company that she didn't handle right. She didn't handle all sorts of other things correctly with contracts, disclosures, etc. I think the fine should be increased.
Erica or Autumn, do you have any comments or questions?
I actually agree with Renee on this one.
Thanks. What do you think the fine should be?
What remind me? We've had so many
It's only
conversations.
it's only 2,500 right now.
Okay.
And you know, I don't know if you have a recommendation.
Is it like, is it an increase to 3,500 or I don't know, Renee, what
You
range?
you can do 2,500 per violation, and there are 6.
Oh,
And
okay.
if we take one out, that's 5. We take it another, that's 4. So you could go easily up to 10. We could go maybe to 5.
I feel good about that. Hopefully it's a number that is memorable enough, and I don't know. It really shocks me that she didn't go to her employing broker for some guidance on this.
And I totally agree with that. Are we on the same page, or how do you guys feel about what I'm saying in regard to the material fact? Are we what are your thoughts on removing that? Again, the fine can be whatever it ends up being, but
I agree with that, Erica, on that aspect, because if they all knew, and I do recall reading that they're offering less, so it's hard to have it both ways. You can't say we're offering less and we didn't know. And they had discussions pointing it out. So I do feel like there wasn't necessarily a failure to disclose on that because there was awareness of those issues. The other issues are there, and it's happening. And I am concerned that there were no discussions and no oversight, whether she didn't go to them or they are just not paying attention. That's a big problem on both sides.
So with the failure to disclose, if that was to be removed, does that go hand in hand with the deliberate misrepresentation and false promise?
I would say it would go hand in hand. But I guess I can ask the investigator that. Was that the intent?
Is it okay if my team lead answers that, please?
Yes.
It did go together, and we thought that it was downplayed very much what was actually going on with the roof, which is why we included the misrepresentation. It felt like, it seemed like she was saying, I'm not filling out a seller's property disclosure. I know nothing. It's a fix and flip, never lived in the property. And so we felt like it was appropriate to have the misrepresentation added to that referral.
Yeah, I would totally agree with that, except for we don't really know, because she did buy it from a wholesaler who didn't do an inspection. She didn't do an inspection. The first buyer didn't do an inspection. So we don't know if her expertise, like the way that I kind of viewed this, she seemed to me like maybe a new investor who may not know all the nuances of this and may not have really understood the level of impact. I think she was very clearly aware of the solarium. I just don't know about what her knowledge of the roof was. And so that's kind of where I had some pause, and I feel like the solarium, everyone was in the loop on that. It was the roof that kind of, I guess, was a big problem, at least for that first buyer. And then the second buyer did an inspection. They addressed the roof in I want to say in an inspection objection. So
The commissioners, the first buyer did an inspection. The first buyer just didn't provide the inspection report to the respondent upon her request. He just chose to terminate. He wasn't going to deal with it at all.
Right. Thank you for clarifying that.
Okay. All right. So if the two are going hand in hand, if you're going to remove the failure to disclose material facts, it seems like it would make sense to remove as well the deliberate misrepresentation and false promise.
And I feel like fines heavy on the incompetent practice, the fact that she didn't submit this file to her brokerage. That's a big issue because it probably would have been a smoother transaction.
Well, I mean, we could definitely up the fine, even removing those, because that still gives us 4 violations. And I think that with, let's see, broker, yeah. I mean, it's a rough learning lesson, right? But there are rules for a reason, and there are protocols for a reason. And this is not an easy industry to be in. So in my opinion, I'm okay with removing those 2 and upping the fine at, because we're allowed to within those 4 standing violations if we get rid of the 2. But those are my thoughts. Anybody else?
Madam Chair, just factually correct. If we will remove C and 4043A, we will be down to 3 violations.
Okay.
But you still are accurate that higher fine can be done here, even with 3 violations.
Okay, so how about we motion to approve staff recommendation? We're going to take out the failure to disclose material fact, and we're going to take out deliberate misrepresented false promise, and we're going to increase the fine to $5,000.
Okay. Thank you for that motion, Renee. Do we have a second?
I'll second.
Thank you, Autumn. Any further discussion? All those in favor?
Aye.
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 Any opposed? Motion passes.
Matter I is complaint number 2024-1836. On September 18th of 2024, the Kansas Real Estate Commission disciplined the respondent for unlicensed real estate broker activity conducted by individuals under the respondent's supervision. The respondent was fined $400 and that has been paid in full. Possible violations are 1210-217-1X, and disciplinary recommendations are diversion and a $250 fine. And Investigator Gabarty can answer any questions.
We have a motion?
I move to accept staff recommendation.
Second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes.
Matter J is complaint number 2025-37. On January 6th of 2025, the respondent's Colorado appraisal license was voluntarily surrendered, same as revocation. The respondent was publicly censured and fined $97,750. The fine was stayed, but it will be due in full if the respondent reapplies for licensure. Possible violations include 1210-217-1AA, and disciplinary recommendations are a final agency order, public censure, revocation, and a fine of $2,500. And Investigator Martinez is here to answer any questions.
Any discussion?
I move to accept staff recommendation.
Second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Matter K is complaint number 2024-2041. On November 23rd, 2024, the respondent pled guilty to theft between $1,000 and $2,000, a class 1 misdemeanor. The respondent was ordered to complete a 1-year deferred sentence and supervised probation. The respondent was also ordered to complete 2 days in jail and pay $5,127.44 in court costs and restitution. The current balance is $4,381.04. A monthly payment plan of $200 per month is in place, and probation is ongoing. Possible violations include 1210-217-1N, 1210-217-1P, 1210-217-1M, 1210-217-1Q. And the next one, I believe you have 1210-405, but it should be 1210-404-1B and Rule Rule 6.23. Disciplinary recommendations include diversion, a fine of $1,000, and probation to run concurrent with a criminal sentence. And again, Investigator Martinez can answer any questions.
Great. Any discussion or a motion?
A motion to accept staff recommendation.
Okay, we have a second?
I'll second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Matter M is complaint number 2024-1179. The complainant listed her home for sale with the respondent, who was her listing agent. The complainant alleged that the respondent did not correctly address that the solar panels attached to her property were leased and not owned. The complainant said that she was not aware that the buyers of her property would not assume the loan until the day before closing, which reduced her net proceeds from the sale by over $14,000. The investigation found that the respondent did not clarify with the seller if the solar panels were leased or owned. The respondent marketed the solar panels in the MLS as owned outright, despite the term that they were leased. A fully executed copy of the amend extend stating that the buyer would pay $12,000 toward the solar panels was not provided to the division. Possible violations include 1210-217-1M, 1210-217-1Q, and again, your copy says 1210-405, but it should be 1210-404-1B, and Rule 6.14A1 and Rule 6.20. Disciplinary recommendations are diversion, a $2,000 fine, and coursework in contracts. And Investigator Peters can help answer any of your questions.
Any discussion or a motion?
I motion to approve staff recommendation.
We have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes.
Matter N is two complaint numbers. Complaint number 2024-2106 and 2024-2030. On October 23rd, 2023, the respondent entered into a final agency order with the Colorado Real Estate Commission. The final agency order called for a 3-month license suspension, 2 years probation, 8 practice audits over 2 years, coursework, public censure, and a $15,000 fine. On November 8th of 2024 and November 21st of 2024, the respondent self-reported license discipline in the states of Maine, Wisconsin, and North Carolina. During the investigation, the respondent also disclosed a disciplinary action in Kansas and a pending disciplinary action in the state of California. Possible violations are 1210-217-1X, and our recommendation is a dismissal with a letter of concern. Investigator Martinez is here to answer any questions.
Commissioners, I did want to provide an update on 2 of the cases. The respondent had emailed me this morning with some status changes. So on the Kansas discipline, he's retained an attorney and is hoping that he'll be able to work out a settlement agreement with Kansas. He's hoping to not have to go through the hearing process, but he is disputing the revocation on that one. And then for the California discipline, he says that he actually did complete the settlement agreement with California. He says he's applied for a new restricted license and also paid the cost on that discipline. So he says that that was just completed within the last week or 2. I haven't been able to contact the state of California to get an update on the license status, but he just provided this email earlier this morning.
With the 8 practice audits over 2 years, so that would have been, that is still ongoing, right? Through the October of 2025, correct?
Correct.
And all of those audits have been up to par.
There has been no report of any issues with the audits at this point.
How many have been done?
Let's don't know if I have a total number on exactly how many they've completed. Let's see.
I mean, because by now we should have been done at least like 4 or 5 of them, right?
Yeah, but I don't know if they gave me a number that was actually completed, but let me just double check for you.
Not finding anything.
So we don't have any record of any audits being done?
I know they've most likely
Yeah,
been.
they have.
I just
Yeah,
don't.
yeah, we don't have an exact number. We didn't ask how many were completed. Just more so whether or not there were any issues identified. But none have been identified at this point.
Do we know that there have been audits done?
So the explanation that was provided was that there were audits that had been done up to this point. However, I think there was an issue with license status as well. Just trying to get to the report. Give me one moment. So it may have been a scenario where while the license status is still on hold, the audits aren't being done. And basically when it becomes active again, then audits will be continued. But give me one second.
So he's inactive right now?
I believe it's in the recording for the my confirmation with them.
Let me look.
Yeah, I'm trying to get into the folder right
An
now.
employing level broker, right? Does he have any employees?
Not that I have record of right now. One second. Okay, so
He doesn't supervise anyone.
Okay. Has he paid the fine?
Let's see.
There's a big fine.
okay, so he just emailed saying 3 audits have been completed. So he's listening on the meeting right now. So he gave us a number. And then on the fine.
Well, he's saying that, but don't we need record of that?
Right, and certainly we can follow up with the regulator to see, but at the time, they just let us know that again there were no issues identified in the audits, but not the number completed. But hold on a
The
second.
fine has been paid. Just answer that question. That's all.
Okay, thanks, Penny.
At least our fine. Is that what you were referring to? From our
Sorry,
case?
what?
The fine from our case, is that
Yeah.
what you, yes, that one has been paid.
Okay.
So I have a question. So if only 3 have been done, and in this, it says they're supposed to be done on a quarterly basis, and I understand what you said about you don't do them when they're inactive. So apparently he had an inactive period. But in our discipline, we wanted 8 audits over 2 years. So are the remaining audits going to happen before October 23rd, 2025?
Yeah, I show 4 have been completed. The last one was completed in January, mid-January. And he is currently active, and I don't know if is Eddie on the call? Would he be able to give us any info on when the next one is scheduled? But there have been 4 completed thus far.
Well, just my question would be, are we going to do those other 4 before October?
I believe
Or
that is
do we look
that-
at extending the audit period within this discipline? I guess, I don't know if we could even do that, but if that's not something that is going to be able to be accomplished within the previous discipline, if we can, I would like to extend that so that we can do our due diligence with those 8 practice audits.
Is Eddie on the call by any chance?
I don't see Eddie here.
Okay.
It's on the call.
Just
So-
these are typically,
So why are we doing a letter of concern? Because normally when someone does something somewhere, we give them a fine and something else. Why is this just a letter of concern?
Because the discipline that they're reporting all starts with our discipline in Colorado.
Oh, so it's come around. Okay. Okay. Oh,
And
we
Commissioners, I was
got a
gonna say,
revocation.
I believe Betsy has done his past audits that are part of the stipulation, and if I remember correctly, there was no finding as a result of the ones that she's done because he hasn't really been doing any business here.
I would still like to make sure those other 4 are done before this, before within that time frame, if we're not going to extend it. I know that makes a lot of work for our staff, but that was part of the discipline, and I would like to see those happen.
We will make sure that he fulfills the term of his existing steps.
Okay.
And are we able to make sure that he fulfills those terms and still go with the recommendation here, which is the letter?
Yeah, they'll be treated separately.
Okay.
Yeah, because if he doesn't fall within those, right, then it comes back to the commission as a violation, right, of his step.
Correct.
Okay. All right. Any other questions? Are we ready to make a motion? Right.
A motion to accept staff recommendation.
Thank you, Renee.
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Right, we are on matter O. Okay, matter O is complaint number 2024-936. The division received a complaint in which the complainant was a buyer and the respondent was a transaction broker working with both the buyer and the seller of a vacant property. The complaint alleged that the respondent did not adequately counsel the complainant to seek expert advice during the due diligence period prior to closing the purchase. The complainant further alleged that the respondent falsely advertised the lot to be a friendly build site where they could, quote, build their dream cabin, when in fact the lot is unbuildable. During the investigation, it appeared that the respondent did not provide proper brokerage relationship disclosure documents and did not sign the settlement statement. Possible violations are 1210-407 2B Part 2, 1210-408 2A1, 1210-217 1M, 12-217 1C, 12-217 1Q, Rule 6.5A and Rule 6.19A. Disciplinary recommendation is a final agency order, public censure, a fine of $6,000, a high level of supervision for 2 years, and coursework in brokerage relationships. Investigator Hardy is here to answer any questions.
Any discussion? We have a motion.
I motion to accept staff recommendation.
Right, we have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes. We've got a few more things on our agenda. Do you mind if we take a quick 5-minute break? Because we have to go into executive session again after licensing. So can we just
Can we make it more of a 7-minute break? That might be helpful. I need a few more minutes. I gotta feed my dogs.
why don't we just come back at 12:40? Let's do just an even 10 and then we'll finish up.
Very appreciative. Thank you.
Back.
Forgot to turn on my video.
All right, we are on to licensing matters.
Licensing matter A is complaint number 2025-11. This is a preliminary advisory opinion. On July 29th, 1999, the applicant was convicted of controlled substance, a class 2 petty offense. The applicant was sentenced to a fine of $118. That case is closed. On December 19th, 2000, applicant was convicted of a controlled substance possession with intent to distribute, Schedule 2, a class 3 felony. The applicant was sentenced to 8 years in the Department of Corrections, which was suspended. 4 years probation. The probation was then revoked, and she was resentenced to 4 years probation and a fine of $1,835. The applicant has completed probation successfully and has paid the fine in full. The case is closed. On August 9th, 2001, the applicant was convicted of a Class 3 felony controlled substance possession Schedule 2. The applicant was sentenced to 12 years Department of Corrections. That sentence was also suspended and sentenced to 4 years probation. Probation was then revoked. She was resentenced to 4 years probation and a fine of $1,835. The applicant has completed probation and the fine has been paid in full. The case is closed. On May 13th, 2002, the applicant was convicted of theft, a Class 4 felony. The applicant was sentenced to 12 years Department of Correction, 4 years probation, resentenced to 4 years probation, and a fine of $7,230 and 53 cents. And the case is closed. And just as a note, we did double check all the fines have been paid in this case.
Discussion?
It was all a long time ago, and I vote for a positive preliminary opinion.
Okay. We have a second?
Second.
All right. First and a second for positive opinion. All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes.
Licensing matter B is an application. It's complaint number 2024-1711. On August 17th, 1999, the applicant was convicted of a misdemeanor possession of drug paraphernalia. That case is closed. In May of 2001, the applicant was convicted of a felony unlawful possession of a controlled substance, methamphetamine, with intent to deliver. Case is closed. In July of 2010, the applicant was convicted of a misdemeanor of carry concealed weapon in a vehicle. Case closed. In November 2011, the applicant was convicted of a felony prohibiting the possession of ammunition. The applicant was sentenced to 180 days in jail, 5 years probation, and a fine of $2,638 with $200 in restitution suspended. The applicant has completed jail and probation terms, and the case is closed. On November 19th, 2014, the applicant was convicted of a felony possession with intent to distribute 50 grams or more of methamphetamine. The applicant was sentenced to 115 months in jail, 4 years probation, and a $100 fine. And probation was completed March 3rd of 2025. As you may remember, the commission reviewed this application at the February 2025 meeting and deferred a decision until after the probation was completed, and it has been completed now.
Okay, thank you. Any discussion or emotion?
I just wanted to kind of get thoughts from commissioners, because I do remember this case. Because the incident was back in 2014, so it was a long time ago, but the probation just ended. Would it feel necessary to do any restrictions? Like, I don't know, maybe, sorry, I'm looking for my options here. Bear with me. I guess should we consider restricting or do we just, consider debt to society paid?
Well, in my opinion, I think this was, over 10 years ago, and the applicant has, repaid their debt to society. And what we wanted was to make sure that they completed the probation successfully. And I think with a new license, you already have that supervision or should have that supervision. So I don't think this case warrants any kind of additional restriction, because none of this had to do with money, commingling money, property management, stuff that we would maybe see some restrictions like that. So I don't see personally that we need any restriction, but
Nope, I move to approve the application.
second. Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes. All right, so we have Attorney General matters, which we need to go into executive session for. So this is Commission Chair Michelle Espinoza. This is a Colorado Real Estate Commission meeting being conducted on April 4th, 2025. The time is now 12:47 p.m. I move that the commission enter into executive session pursuant to Colorado Revised Statute Section 24-6-4023A2 for the following purpose: to confer with counsel to receive legal advice on specific legal questions regarding the following meeting agenda items. To receive legal advice regarding matter, A, which is complaint number 2022-1874 and 2023-1847. And also to receive legal advice on recently enacted statutory requirements. Oh, sorry, that piece is not there. To receive advice on the counteroffer submitted in Attorney General matter, which I just read. Sorry, my script is a little backwards. And finally, to receive legal advice regarding Attorney General matter B, complaint number 2023-2377. Is there a second?
Second.
Thank you. All those in favor?
Aye.
Aye.
All right, there are 5 votes to go into executive session. Please make sure your audio and your video are off. Looks like all of us are back. So we have two matters. We have Attorney General matters on the table. So in regards to complaint number 2022-1874 and 2023-1847. Do we have a motion?
I motion that we approve the counteroffer from respondent.
We have a second?
Second.
Second.
Thank you. All those in favor?
Aye.
Aye. Any opposed? Motion passes. For complaint number 2023-2377, do we have a motion?
I motion to approve the counteroffer from respondent.
Do we have a second?
Second.
Thank you. All those in favor?
Aye.
Aye. Any opposed? Motion passes. This does conclude our meeting today on April 1st, 2025. And before I release everybody, or not release, you guys can go, but this is my last commission meeting. So it has been a great 6 years. It has been a pleasure to work with division staff, with Director Waters. And it's been a great experience. I wish you all the best. I will probably be one of those participants in the audience every meeting. So I wish you all luck. Thank you for the opportunity to serve. And everybody have a great afternoon.
Thanks,
Thanks,
you
Michelle.
for everything you've done, Michelle.
For all your service.
Thank you,
Thank you.
Michelle. We really appreciated all your work and we're going to miss you.
Ditto.
You don't want to come back and run the meeting, you know?
I don't think that's allowed, but all right, all. Thank you so much. Have a great day.
All right.
Bye.
Bye.